Good morning and welcome to Advocation's Training Thursday's August webinar, the Accessibility for Ontarians with Disabilities Act, What You Need to Know and Do. For those of you who are new to the webinar or who are new to me, my name is Hermie Abraham and I am an employment lawyer and the owner and operator, excuse me, of Advocation Professional Corporation. We are an employment law firm, and we help both employers and employees with their workplace issues. I created these training series because there is a need to provide information to human resources professionals, to business owners, that doesn't necessarily require always having to see a lawyer. So these webinars are meant to address some of the main topics that you'll face in your workplace pertaining to your human resource issues on a day-to-day basis. And again, I encourage you to provide me with topics. I am doing programming for the month for the year of 2017. I've already received a number of topics from individuals, and I look forward to receiving more. So if there's a topic that you would like me to cover in the webinars for 2017, definitely do let me know. I would very much like to cover it. Now, as you know, the Training Thursdays are held on the third Thursday of each month at 9:00 a.m. and the webinars are for approximately 30 minutes. Sometimes we go over a bit. A little bit of housekeeping before we begin. We're using the Google Hangout platform, and as a result, there might be a slight delay between my interaction with you and your interaction with me. So as a result, I say don't pause the webinar. If you pause the webinar, you will not be live. You will be able to pick up from where you left off, but you won't be live and you will not be getting live feed. So if you think you're interacting with us, you're going to be delayed by minutes. It could be that the webinar might be even over. Also, there is a chat box for you to submit your written questions. Please do put your questions there. I will answer questions at the end of the webinar. And again, if you do have any additional questions or follow-ups, please do send them to me at the email address that's displayed. But without further ado, we will get started. And the topic this month is the Accessibility for Ontarians with Disabilities Act. It is a relatively new legislation as far as private sector workplaces are concerned. There was a previous version of the Accessibility for Ontarians with Disabilities Act, which I will refer to as AODA moving forward because it's a bit of a mouthful to say and to write out in the slide. So you'll see it referenced as AODA. So there was a precursor to AODA, which was the Ontarians with Disabilities Act, and that came out in 2001. And that particular legislation was very limited. It really only created obligations for private sector organizations. And so AODA was created in 2005, to be able to create broader obligations for not only public sector, but also with private sector as well. So today we're going to review a little bit about the legislation, what you should know, some of the top things that you should know. We're going to examine the employment standard with AODA, and we're also going to review some of the compliance activities and timelines and discuss some best practices within the employment standard for your organization. So a little bit about AODA. It, again, was developed in 2005, was implemented in 2005 with the purpose of developing, implementing, and enforcing accessibility standards in order to achieve accessibility for Ontarians with disabilities. And this was to be done with a focus on some key areas and with the target completion date of January 1st, 2025. We're getting very close to that, not very far away. And with AODA, you'll see that it does apply to every person or organization in the public and private sectors in Ontario. So what AODA does not apply to, or what it doesn't regulate, are federally regulated organizations. So if you have a federally regulated organization such as a bank, railway, telecommunications, you're not going to have the AODA standards apply to you. And if you have a workplace that has employees outside of Ontario, even if they might be reporting into Ontario, but they're outside of Ontario, they would not necessarily be covered under the ambit of AODA. Although, again, it's always a good best practice to make sure that your workplace is accessibility compliant for not only people within Ontario, but other people who might have to access your organization from outside of Ontario. With respects to AODA and the Human Rights Code, sometimes there's communications with, there's not communications, but there's a sense of conflict between the two legislation. There isn't a conflict between AODA and human rights. They basically work in concert with the code having primacy. You will see that AODA does borrow the definition of disability that's found under the Human Rights Code, which is a very broad definition. It doesn't only look at physical disabilities, but also looks at mental disabilities. It looks at permanent impairments, as well as temporary impairments. Some ways that AODA and the Human Rights Code are different, though, is that the code focuses on equality and trying to make Ontario an even playing field for people with disabilities. AODA really just focuses on accessibility and trying to create a more accessible framework so people with disabilities can participate equally. The code also looks at more than disability. It has a number of protected grounds, such as race, place of origin. AODA really, again, is only focused on disability. And as mentioned, the code has primacy. So if there is a conflict between AODA and the Human Rights Code, and truly AODA and any other legislation that might give a greater benefit to a person with disability, then that particular legislation will have primacy. The code looks at many areas within our general society, so it doesn't only focus on employment or some of the standards that we find in AODA, so it can apply broadly, whereas AODA really is focused on specific standard areas and compliance within those standard areas. And so where the code seeks to sort of even the playing field, think of AODA as a way of creating more accessibility so people can participate equally. Now, there are a number of standards under AODA, and I should say that the legislation really has two parts. It has the actual legislation, which talks about why we have AODA, how it's current and enforced, how it's going to be complied with, what you need to do to comply. And then there's the regulations or the standards, and the standards are more specific about what is needed under each of the different categories, and we'll look at the categories now. So the regulations have the standards. The regulations have been recently updated. There used to be two regulations. One was a customer service standard and an integrated accessibility regulation. That has now been merged, so there's now just one regulation under AODA, and this particular regulation covers all of the standards that you see listed on this particular slide. Now, I don't purport to know all areas of AODA. I really do focus in on the employment standard because that is the one that touches my area of law specifically. And this presentation is really only looking at the AODA employment standard. Recognize that within your workplace, there might be many standards that apply to you. And if you have questions about the additional standards and what you should be doing, I would be happy to make a referral to another lawyer who might be able to assist you if it's, whether it's transportation or the design of public spaces, because it is important that you understand that your compliance will not be just under the employment standard, but all aspects of the AODA regulations that apply to your organization. So the way that these particular standards, the customer service standard, employment standard, information and communication standard, and so on, have been put together is by looking at key areas that require a focus on accessibility, if you will. And the AODA legislation does make the provision for the government to continue to expand standards as necessary to meet the purpose and objective of the legislation. But as it stands, these are the standards that we have right now. Now, within each of these standards, there are different classes, and there are different ways that they will apply based on the class. So, for example, there are classes based on whether you're a public or a private sector organization. Public sector organizations obviously have greater obligations than private sector obligations because the government does want to be able to take lead on creating accessibility within Ontario, with the private sector's following suite. So you will find greater requirements on public sector organizations in AODA and greater standards for the public sector within AODA versus the private private sector. And you'll also find that there's a class with respects to the size of your organization. So with AODA, depending on the size of your organization, which has changed, and I'm going to now start a poll just to be able to see where people fall. There is sizes based on whether you have 1 to 49 employees or whether or not you have more than 50 employees within Ontario. And recognize that with the standards and the size of the organization, the way that you are counting the people who are employees are based on people who you essentially pay. So contract, full-time, seasonal workers would be included within your workforce. Anybody you pay salary, you have control over their work. The people who are not counted when you are looking at the number of employees within your workplaces are those who work outside of Ontario, obviously, and volunteers and independent contractors. Most of the people on the call seem to have more than 50 employees, so as private sector organizations and public sector organizations for that, but again, this presentation is only going to focus on private sector. But for private sector employers with more than 50, you do have greater requirements under AODA, and we'll look at those. So let's start looking at the employment standard. The employment standard and the AODA regulations really form a few sections, about 10 sections of the legislation. And they can be categorized in nice clean buckets, which are recruitment and selection, workplace accommodation, and performance management. So we'll look at each of these in turn. Now, with recruitment and selection, what AODA requires employers to do under the employment standard is to notify employees and the public about accommodation that's available, both generally through the recruitment process, when a candidate has been selected for interview or even selected to join your organization. And although the standard doesn't say how employers are supposed to let employees and the general public know about the accommodations that are available, there are some best practices that I recommend. One is that in your job descriptions that are posted both internally and externally, you should have a statement that says ABC Company, for example, ABC Company is committed to providing accommodations for people with disabilities. If you require an accommodation, please make your needs known. We'll work with you to meet your needs. I will provide a tip sheet, as I always do at the end of the webinar series, with some of the best practices and some wording for you and some tools and resources to ensure you're AODA compliant. So don't worry about taking notes or having to write that statement in. But I do think that you should include as a best practice in all of your job descriptions a statement. And I think that that will not only help you as far as AODA compliance is concerned, but also as far as human rights compliance is concerned. So a statement that lets people know in the public, if they're applying to work for you or within your organization, that they can receive accommodation. If a candidate is selected for an interview, in the either call or email that you send to that particular candidate, the same statement can be included, and they might be also provided with a point person that they can contact should they require accommodation. Now, that's a best practice I think would be useful. AODA standard does not say that you have to have a point person within your organization, but I think, and we'll see as we talk about the slides or we go through the slides, that it is really helpful to have one person within your organization, or many people, that is sort of looking over your AODA compliance, because these are the things that can kind of get lost from day to day. So if you have a point person who kind of looks at your disability and accommodation within your organization, I do think that you'll be well served, and it will help you not only with AODA, but also meeting your Human Rights Code compliance. And with respects to the Successful applicants, again, in your offer letters include the fact that you do have a AODA policy. You might want to include the copy of the policy so the employee understands what's required of not only the organization in accommodating their needs, but also of the employee in making sure that their needs are brought forward. The next piece we'll look at under the employment standard is workplace accommodation. And that spans over a number of, in fact, it's probably the bulk of the employment standard, and it spans over sections 25 to 29 of the legislation. First thing that it does do is that it requires employers to have a far more rigorous way of implementing an accommodation program for employees with disabilities. And with that, I'm going to ask another poll question to see how many of you do have employees who might be on leave right now. So the workplace accommodation, as it applies to this sort of more rigorous program, applies only to employers who have more than 50 employees within their workplace. So for the bulk of you on the webinar, that will be your situation. And what it does is it requires employers to have a documented individual accommodation plan, as well as a return to work process. And I say that this creates a great opportunity for employers to be able to look at a more formal disability and leave of absence and accommodation management program that can form part, which AODA would form part of, and again, would help you with your human rights compliance. A number of you have employees who are on medical leave of absences or who have active accommodation requests. So for that reason alone, it is more important to have a program in place so you know that you're meeting your compliance and nobody's falling through the cracks. So what would be part of this particular disability and accessibility program? Well, one, you would want to ensure that you are explaining AODA's AODA within your organization, the code, and what disability management and accommodation is within your organization. I say it's always helpful to have training, maybe as part of your induction program, where you're not only including the policies, but again explaining what they mean, how they're lived within your organization, and what employees are required to do. You should also include as part of your program the steps that employees need to take to request accommodation. And those should be clearly laid out, who they should be speaking to, whether it's a point person that you're appointing within your organization or their manager, to be able to identify their accommodation needs. The program should also include how accommodation needs will be assessed and provided or denied. Recognize that as an employer, you don't have to provide accommodations completely. It's not an absolute obligation. It is to the point of undue hardship. So you want to make sure that you let employees know that there is a standard or a limit that you can reach, but you want to be able to explain how they will, how you will assess their accommodation needs. The AODA legislation does require that employers detail and let employees know how their privacy will be maintained. And again, I think that if you have one point person who is handling accommodation requests, who is working with the employees who are in need of accommodation, and their physicians and doctors who are helping them with their, whether it's rehabilitation or being able to provide you with the functional abilities, you can ensure that the information is secured all the better, rather than it being with individual managers. And when a manager leaves, not knowing where that information goes. And the accommodation program should definitely explain how the accommodation plan, the individual accommodation plans for employees, will be implemented, they'll be reviewed, and they will be modified. Because you want to recognize that an individual accommodation plan is a living, breathing document, and you want to make sure that you are on top of it all the time. Now, as far as return to work is concerned, there should be also a process that's included as part of your overall accessibility management program. And that would be ensuring that there's a process for following up with employees on leave of absence, whether it is at specific intervals or dates based on information they've provided to you, or just on your own calendar or, tickler list. So you can understand whether or not there is the ongoing need for the leave of absence, and whether or not you have up-to-date functional abilities information about the person who is on the leave, and you're constantly assessing whether or not there's something that they can do within the organization to return them to work. You should know the return to work dates. Unfortunately, a number of organizations aren't aware of the return to work dates of employees. It's very important that you have that calendared and that you're ready for the person when they return to work. And I say that as far as their return to work, when they arrive, you should have accommodation plan that you're working with them, hopefully in the time leading to their return to work, accommodation plan that they can review, that you're implementing, as well as providing them with support. So again, if you have a point person within your organization who is going to be your sort of AODA compliance person or your accessibility point person, that the employee who is returned to work can use that person as a resource just to be able to raise any issues if they encounter issues upon their return to work or have any issues with the specific accommodation plan. Also under the workplace accommodation sort of category are general standards that apply to not only employees who have accessibility issues, but your workplace generally. And what the AODA employment standard requires you to do is to inform employees of the AODA policy, which I say is best done in a training session or an induction session. Provide accessible formats and communication supports to employees who request it, and also provide a workplace emergency response plan for employees who might need it. And as far as best practices, I say that, again, provide training to employees. And the training is very important because, again, employees have a reciprocal duty to be able to provide you with information that they need regarding their accommodation needs. And if you can show that you've provided employees with a training program that has explained what they need to do, and that the employee has not made their needs known to you if they require accommodation, you're not going to be held liable under the Human Rights Code or AODA. So it is very important to show that employees are aware of their obligations, and training is always a wonderful way of making sure that that is so. With respects to the accessible formats, there's two ways that this can be done. Obviously, if there's an employee who requires a specific assisted device, you'll want to make sure that that's included on their accommodation plan. However, I always say that within an organization, there are people who might benefit from some of the devices that are available to people with accessibility issues. So some people might have not full hearing loss, but partial hearing loss. And so if you have a device that helps people in large meeting rooms be able to hear in the back of the room and listen to people talk, then that's something that will benefit the whole organization. So you might look to have just accessible formats available, even if it's not within a specific accommodation plan. And with respects to the personal emergency response plan, I say that you should look at all the areas within your organization where there might be emergency. Main one we all know about is a fire drill. Everybody has the fire drills. Within your fire drill protocol, you should account for people with disabilities. So if there's somebody who has a hearing impairment, there should be a protocol created to be able to make sure that they're aware of any sort of fire drills if they cannot hear any alarm that's sounding. Similar to somebody with a physical impairment, if they're unable to be able to take the stairs or something, there should be some kind of backup plan that shows that you're going to be able to meet their needs if there's emergency. And again, that you'll want to make sure that that is documented and included in the individual accommodation plan. And the last area within AODA, within the AODA employment standard, is with respects to, I call it performance management broadly. It's also really the retention and redeployment of employees. And basically what the standard requires is that employers take accessibility needs and individual plans, accommodation plans into account when you're looking at performance management, when you're looking at career development, and when you're looking to move somebody into a different position. And there is really no best practice apart from the just do it. I think that with people with disabilities, oftentimes there is they're held back, or at least they're limited within an organization, because sometimes people aren't actively looking at how they can progress and grow within the organization. And so as part of the ongoing living, breathing accommodation plan, you might want to look at different roles that the person might be able to transition and move into if they have the skill set for, and how you will meet their accommodation needs along the way. Obviously, if there's a formal job change, then you'll want to make sure that the accommodation plan is also reviewed with that job change to ensure that any accommodations that might be necessary for that new job that are not part of the accommodation plan are then included. Now, the last thing I'd like to conclude with is looking at the compliance timelines. And for most of you, you should have already done many of the employment standards that we have gone through. I will look at it first with less than 50 employees. And before that, I'll just say generally that compliance under AODA is done in two ways. There is the annual reports, or the reports that are filed, not annually, but every 2 years by organizations that have more than 50 employees. In 2014, it was less than 20 employees, but that's now been changed. So moving forward, it will only be at workplaces with more than 50 employees. So there's annual reporting that you have to do. As well, there are inspections that are done by AODA inspectors. And these inspectors will get their marching orders from either organizations that haven't completed their compliance reports, that should have completed their compliance reports. They will then do investigations within those workplaces. Recently, they've also created a 1-800 number, a toll-free number for members of the public to call and or employees to call within your workplace if they believe that AODA is being breached, and that would also obviously trigger could trigger an inspection. So that's how AODA is enforced. The compliance is based on the size of your organization. There was a change in July of 2016, so just recently, where the categories, the size categories have changed. It used to be 1 to 20, 20 plus, and then 50 plus, or 20 to 50 and then 50 plus. Now it is 1 to 50, and then 50 or more, or 1 to 49, I guess, and 50 or more. So note that if you do have at least 20 employees in your workplace by 2014, you should have filed your accessibility compliance report. You can do that still online. There's about 20 questions that you answer to be able to sort of answer whether or not you've met the timelines for compliance under a number of categories, not only employment, but the other standards that are required for your organization. You should have emergency plans together if you have less than 50 employees. And by 2017, you will be required to implement the recruitment, workplace accommodation, and performance management directives that we just reviewed. With organizations that have more than 50 employees, well, by now you should be essentially compliant, or you should have met all of the directives within the organization. So you should have within the legislation, sorry. So your organization should have emergency plan for employees who have indicated that they will require accommodation for emergency. You should have created and communicated your AODA policies. That should have been done in 2014. And your first accessibility compliance report should have been filed on December 31st of 2014. This year, at the beginning of this year, you were required to implement the recruitment, workplace accommodation, and performance management directives, which means that you should have a workplace accommodation plan, and you should have a return to work plan for all employees who are on disabilities and on a leave of absence and have disabilities. So you want to do an audit to make sure that you have those. And in terms of future looking forward, the next activity that you'll have as employers with more than 50 employees is to file accessibility compliance report by December 31st of 2017, and then every 3 years thereafter. Now, again, this is what you have to do now. The legislation is constantly changing, so make sure that you keep on top of the updates that I'll provide to you. I'll always provide updates if there are if there's information or changes to the legislation that will impact employers. But if there are new standards or new directives, you want to make sure that you're on top of them. So although future looking right now, you only have to do accessibility compliance reports, it's very possible that there might be more required of you in the future. So with that, I will take questions, and I'll see if there are any. I don't see any questions. Does anybody have any questions with respects to the presentation or standards? Now, what I will say is that the tip sheets that I provide to you will have some best practices as well as links to tools that are available on various public organizations that will help you meet your AODA compliance if you haven't already met it, or even it will allow you to check and see if you are compliant. So definitely do look at the tip sheet that should be coming to you in a week, and you'll be able to get some helpful tips on how to remain compliant within AODA. Thank you very much for your time. If there aren't any other questions, again, I appreciate the time that you spent with me this morning. I look forward to seeing you next month on September 15th, when I will have and be hosting a live Q&A. This one won't be a scheduled or a specific presentation, but a chance for you to provide any questions and ask questions live about any area of employment law, labor law that might be of interest in keeping you up at night. So again, thank you very much. I appreciate your time, and I look forward to seeing you next month.